Hi there, this is Jonathan Ginsberg, and I'd like to talk to you today about some things you can do at your hearing that will really enhance your credibility, make your case stronger, improve your chances of winning. And this really has to do with any sort of work attempts you've made, any sort of school attempts you've made. A lot of times when you start with your attorney, it can be 2 years before your hearing. It can take 1.5 years, 2 years before you get to your hearing. And during that 2 years, you may try to work. You may try to go back to school. And these are things that are not going to be in your intake form. Your attorney may not know about them. So it's really important that you describe and talk to your attorney about anything you've done. Let me give you an example. I had a case recently where my client had significant back problems. He had not worked for a couple of years, 2 or 3 years. And he came initially to see me about 2 years before the hearing. We have our hearing, and before the hearing, I'm talking to him, and he is telling me about, he's doing this, he's doing that. And I said to him, well, have you tried to work any place? And he's like, no, I really hadn't. I said, well, have you done anything for pay at all? And he said, well, is there anything I tell you confidential? I'm thinking, great, this is not going to be good. But I said, yes, of course, everything's confidential. He said to me, well, this summer I had some friends who were moving and they knew how to pick up truck. And so they basically hired me to drive the truck. I didn't lift anything. I didn't unload or load. I just drove the truck, 4 or 5 miles from the old house to the new house. And I did this for 3 or 4 days in the course of a week, and I got paid $150. And, again, it's not a problem because it doesn't really suggest he's doing any kind of work. But what that says is that he's trying any way he can to make money. I said further, well, if this was available to you as a full-time job, could you do it? No, I couldn't really do that because I was in bed for 3 days after this. It was all I could do to make it those 3 days. And I used that in the hearing to show, and I had him testify about this, to show that he was really trying to work. He was trying to do something to make a little bit of money. Judges understand that people are under financial stress, and the fact that he was trying to do it but he couldn't do it, that was evidence in his favor. Another example, I had a client who tried to go back to school. He had been doing physical work, and he couldn't do that anymore because of a significant back injury. So he tried to go, he enrolled in a local community college. He was going to take a computer course so he could do some work at home out of his house on the computer. And the fact that he tried this, it only lasted a month. He said, I had to drop out because I couldn't sit in class long enough. I couldn't pay attention because of the medications, and I just couldn't do it. Well, he tried, and the fact that he tried to work was in his favor. It showed that tried to go to school was in his favor because school is kind of like a work-like activity. So we brought that up at the hearing, and he testified that he tried to go to school because you want to show the judge you're trying everything you can not to be disabled, that if you could find a job within your capacity, you would do it even though you're in a certain level of pain. But the fact that this guy couldn't go to school part-time, this is maybe 3 days a week, for an hour, he couldn't stick with it because it was just too much for him. That worked in his favor. That was a positive thing for his credibility. So anytime you have a work attempt, a school attempt, these are things you need to talk to your attorney about so that your attorney knows he can make those things a positive. By contrast, if you don't bring it up and it comes out, if you mention it to your doctor and it shows up in the medical record, it looks like you're hiding something. So I'd much rather have a situation where somebody has tried to work, has gotten through a few days or a few weeks. I can use it to show that he couldn't do something, but really tried. That's much better than having the judge bring it up and saying, I'm seeing this in your medical record, and it turns out that my client didn't mention it before. It looks like he's hiding something. Because the judge will assume if you didn't mention this and I caught you on it, there may be 5 other things that you've been doing that you haven't mentioned as well. So again, these are things that can really, really help your credibility, make you a lot more believable at a hearing. Goes a long way to improving your chances at victory. So these are some things I would definitely think about before your hearing. Talk to your lawyer and do everything you can to show that you are fighting this whole concept of disability. You don't want to be disabled, but you want to rejoin the workforce as soon as possible, as soon as you're medically able to do so. So again, I hope this has been helpful. I'm Jonathan Ginsberg. Any questions, please let me know. Thanks a lot.